would mess up the technology. You got it? All right, here's our second one. I represent a client in a case that ends up being reported. There's a decision out there for anybody in the books, also Lexis, Westlaw, free resources, etc. Can I tell others about what has happened in that case? Then finally, we have another scenario. What about a public court proceeding? Anybody can walk into the courtroom, see what's going on. Can I live tweet or blog about what's happening there? All of these three scenarios bring up the confidentiality rule. And under every single one of them, the confidentiality rule says, no, you lawyer can't disclose that information. And that's usually, when I talk to lawyers about this, they give me this sort of face and say, what are you talking about? I can't discuss what's in a published opinion. I can't discuss what happened in the courtroom the other day that's open to the public and anybody can come into. Well, the issue has to do with what is confidential and what we mean by getting our client's permission to go forward. So yes, you can talk about these things if you get a green light, informed consent. But we really need to know what is confidential. Under the confidentiality rules, if something is related to the representation, no matter what its source, it is confidential information. We can only disclose it for a couple of reasons. We're impliedly authorized to. So if I have to go to court and make a claim, I have to put information out there in order to prove my client's case. But that doesn't mean I can later go up on my website and say, I got this great victory in a case, take a look at the published opinion. The ABA has said, you know, published opinions, if you've represented a client, you need their permission, their informed consent, before you go and list them on your website. That sounds a little bit crazy. The information is already out there. Somebody could find it if they want to in a web search. How easy is it to put my last name? By the way, my last name is Iannarone. It's not very common. You stick that into Westlaw, you're going to find almost all of my published decisions and cases that aren't published. The rationale, though, behind it is this. Let's say I represented somebody accused of a really, really terrible crime. Best example I've ever heard is someone who's required to register under a sex offender registry. And let's say that I do a great job as a lawyer and I am able to ensure that that person doesn't have to go to prison. We're able to get out of the charges somehow. Now, that client probably doesn't want me talking about the charges that were against them. As his lawyer, I owe him duties to put his interests before mine. And if I'm going around and saying, look at this great victory against this guy accused of a horrible crime, I am amplifying the information that's out there and making it easier for others to find. You can think about the same thing perhaps in a tax dispute, right? Someone might be embarrassed to know that they were charged with owing extra taxes. They want to keep the information as low-key as possible. So I like to think about it this way. If I were embarrassed to ask my client, is it okay if I publicize that we won this case? I probably shouldn't ask to begin with, and I most certainly don't want to go and put it up on my website. A lot of corporate clients in particular have now started including in their engagement letters language that says something to the effect of, you're not going to talk about our case at all, and you're not even allowed to tell people that you represent us on your website. You're not using that as advertising. So let's go back to our example of the leopard printed underwear that we had before. Told you that was a real case. Public defender in Florida. She thought that she was posting a photo. This is a stock photo, not the actual one. I haven't been able to find that one, but I'm sure some people in this room could find the evidence in that particular case for me. So in this scenario, she had thought she was just taking a quick picture. How easy is it to pull out your smartphone, take a picture, post something, put a couple of words on it? Her friend list was, she thought, private, very small. She had as much security as she could on it. one of her friends happened to be a lawyer and sent a copy of the post to the judge. And it turns out that in this case, the client to whom she was appointed to represent had said over and over again in motions, I'm having a really hard time working with this lawyer. I want a different public defender. This relationship isn't working out very well. Well, the judge saw this post, immediately declared a mistrial. Her bosses in the public defender's office fired her. And that was that. She thought private on Facebook meant private. It doesn't. We all know that. Even if you delete things, it's pretty easy to, well, not for some of you, again, easier than maybe for me, to find stuff. The Wayback Machine can show it to you. Others can take pictures. We even know that Snapchat isn't as not permanent as folks may have first thought when it came out. So here's another real life example. There was a lawyer, I think he might have been in Chicago, somewhere in the Midwest, and he was representing someone who had been accused of drug trafficking. There was a video in that case of where the prosecution said, you know, this individual caught by undercover agents purchasing drugs, sent it to the defense lawyer who thought, I don't think that shows what I think it shows. So the defense lawyer puts it up on YouTube along with the storyline of police framing innocent client. It gets thousands of views. The prosecutor finds out about it, gives the lawyer a call and says, I think you need to take another look at what is going on here. And the defense lawyer watches it one more time and says, you know what? You're right, that does show my client buying drugs. So not only has this guy released confidential information, it's related to the representation, he's also put horrible information out there against his client, who then fired him. And of course, and she had a really hard time getting further employment. Her family had no idea that she had been charged with this particular crime. This comes from my Facebook feed. Someone, I was researching for class a while ago, and a friend of mine who is general counsel for a local corporation put this post up there. Attorney friends, I'm writing an MSJ, motion for summary judgment, and I'd love to see any briefs on my key legal issue, 1981 claims as well as the ADA regarded as amended. Can you send me anything? Well, it might make sense to see legal research. I'm not sure I'd do it over Facebook. Might be a confidence issue, perhaps. It also raises some questions about confidentiality. I know where this person works. I know exactly now what she's working on, and I've got a good idea about what her main argument in a case is going to be. If I'm the other side, I would start working on it real fast. So this would also be a violation, one that somebody didn't think about. I see this a lot on my Facebook feed. Hey, can you all help me out with a research request? And quite often, if you know enough about the individuals and what they're working on, you can tie it back to the exact case, and it is releasing confidential and oftentimes privileged information, which might be even worse. So I mentioned Whisper before, right? Some of you might have heard of, where you can just post your deepest, darkest secrets, allegedly anonymously. I like this one up here. I'm a lawyer, and when I'm absolutely sure that my client is guilty of a federal crime, I purposely lose the case. That's a terrible admission to put out there, and I'm wondering if they know that someone can probably figure out who they were. I see down here there's a location tag. Marietta Hot Springs. I don't know where that is, but it doesn't sound like a large place to me. Someone can probably find out who they are. It is not anonymous. This individual is not aware of how the social media can be used. Obviously, this is a big problem for the profession, both in terms of our obligations to our clients, and someone is not thinking before they post. So we've talked a little bit about competence. We've talked some about confidentiality. I want to shift gears a little bit and talk about lawyer advertising. When I talk to lawyers in groups like this, particularly about social media, I'll ask them, how many of you guys advertise? None of them ever raised their hands. Then I asked some questions. Do you have a firm website? Do you have an internet presence anywhere? What about a LinkedIn page? Do you tweet about work ever? Law firm account? Do you post about work on Facebook? Then I ask again, do you advertise? Pretty much everyone's hands go up. We don't think about these newer types of technologies as traditional lawyer advertising, but they most certainly are, and they're subject to the same rules. The main rule of lawyer advertising is that whatever we put out there has to be truthful and not misleading, which seems pretty easy, but can be challenging for some lawyers. It's also challenging for bar disciplinary folks to figure out what to do. This is a screenshot from my LinkedIn page. I've covered up photos and names to protect the innocent. A number of people have endorsed me for all sorts of things, like legal writing, litigation appeals, research, commercial litigation. I don't have endorsements on my LinkedIn page because I feel a little bit weird about them. Bars had a hard time dealing with how do we treat endorsements in terms of advertising. One of the people whose faces I've covered up is my 20-something-year-old cousin. She runs social media at a Fortune 500 company, and she has endorsed me for legal writing. My 20-year-old cousin has never seen anything I have ever written for a client or filed with a court. And the question becomes, can I accept her endorsement? Is it truthful and not misleading that somebody thinks I'm great at legal writing, but they've never seen anything that I have ever written? Well, state bars have come up with different answers about it. This is one of those situations where you want to go and look specifically in your jurisdiction. South Carolina, one of our neighbors, had more troubles with this one than others, and they said, you know what? We don't want you putting endorsements up because it could mislead somebody and suggest that you are qualified or specialized in an area that the bar has not said you are specialized within. Other jurisdictions have said, this is crazy. The general public can understand that someone may think highly of your reputation whether they've seen your work or not. Come on, this is pretty straightforward now. Florida, for a while, had a problem with the idea of friends on Facebook. Judges couldn't be friends with lawyers because it implied they had a special relationship with the lawyers with whom they were friending on Facebook. Sounds a little crazy to us when we think about the types of friend requests we get, and many of them aren't friends at all. They're just people we run into from time to time. This is another post from Facebook that someone once sent me, or a screenshot of it. This is someone who's a criminal defense lawyer. I'll give you a second to take a look at that one. You're probably wondering at this point, why did I put this under the part where we're talking about advertising? Well, my lawyer friend who sent this to me is a good lawyer and recognizes that we lawyers have a rule that says, here in Georgia, it's not mandatory, many jurisdictions it is, but here in Georgia, you should report any violations of the rules of professional conduct. You should work with lawyers who have screwed something up and talk to them about it. So my friend called this lawyer and said, hey, I was looking at your Facebook feed, and I have to tell you, I saw a story on there that really concerned me. Your client might now be in a situation where the police can see that, and you've released the substance of a conversation that you had with them. The lawyer's response, oh, that's not actually a true story. Everyone who's on my Facebook feed likes my client stories. I'm sort of making them up and putting them together to include in a book. So this raises some questions of is this lawyer putting out misleading information in violation of the advertising rules to try and get money, and really is making the profession look bad and make people think that it's okay to share these stories. It's not. Now, I find it rather interesting that in social media we see stuff like this now. It's exactly what we used to see in cocktail parties. You ask a lawyer, what are you working on? And you might hear these things. Now there's proof of it. Still the same violation. If it's true, it's a violation of confidentiality. If it's false and you're trying to put it out there to get more business or to sell a book, you're probably in violation of the advertising rules. No matter which one it is, you are guilty of making really, really bad decisions. Now, advertising rules are very, very quirky. Not a First Amendment lawyer, but we have one who knows a lot more about it than I do, who might be able to help us if we get into the mechanics of it. In Georgia, at least, we have a new advertising rule that says if you're going to go out there and blog, have a website, do any type of advertisement, you need to have on the ad the name of the person responsible for the statement and how to contact them. I've given you 2 screenshots of the blog that we use in our clinic that students put together, where I take responsibility for all the things that my students write and put up there. And if the bar has a problem with our advertising, then they can come and let me know. This is where lawyers also say, a blog isn't advertising. It is. It is advertising for lawyers because we're trying to put something out there to show that we are good at what we do and convince individuals to hire us. In my case, I might be able to quibble with the bar by saying, I don't get paid by clients for what I do. It's not advertising in the same sense. Nevertheless, I want to make sure that I follow those rules, and this is a plug for looking up what your rules are within your jurisdiction. The most restrictive that I know of, and almost all the First Amendment cases about lawyer advertising come out of one state, and that is Florida. If you practice in Florida, work with Florida lawyers, be careful about their rules. They have all sorts of quirky guidelines, and they do prosecute lawyers for not exactly meeting the stringent requirements of those rules. More and more, we're starting to see clients proactively going out there and rating their lawyers. All sorts of sites like Avo, Martindale, even Yelp, where clients will say, I had an experience with a lawyer, it went really badly. Don't hire this person under any circumstance whatsoever. Lawyers have a really hard time not responding to those. Here in Georgia, we recently had a lawyer who was suspended for somewhere between 6 months and a year for responding to a Yelp post. And frankly, this client had gone every single site she could think of to post about how terrible the lawyer was, she went to. So it was all over the internet, smaller town lawyer, family law practice. And the lawyer said, not my fault, that bad things happened, and then disclosed something along the lines of, you had an adulterous relationship and that's why you didn't win within the divorce. Okay, confidential information, disclosed, disciplinary folks say, no go, and you get suspended. Georgia's not the only place where this has happened. Same has happened in Illinois, I believe Wisconsin, and we're having a hard time dealing with it within the bar. And Chris sent me an article the other day of, let me step back. Confidentiality rules say lawyers can respond to a dispute or controversy with a client and can disclose confidential information. It wouldn't be fair to say, client can throw something out there and tell you you can't respond to it at all. They can charge you with a disciplinary offense, but you can't defend yourself. We're having a really hard time dealing with these new types of social media because it's not a case, but it's definitely a controversy. And one could argue that Yelp and Avo and Martindale could hurt someone a lot more than a disciplinary complaint that by and large is confidential, particularly for the first time someone has been charged with discipline. So weirdly, although we can defend ourselves if we're sued or if someone brings a disciplinary complaint against us, we haven't construed controversy to mean responding to this sort of stuff. So different scholars are proposing other solutions. Maybe we have online reputation management out there, a system where you can challenge what a client has put out without getting too much confidential information. Some bar folks say lawyers don't respond at all. It's better that way. It won't be escalated. No one's going to hear about it if you don't respond. It's really a challenging one, and we're still trying to work through it. The best I can tell someone to do if they've got a bad review on one of these with which they totally disagree is to say, I'm terribly sorry that you had an experience that you didn't think was up to your standards. I strive to provide the best service I possibly can for everybody, and by ethics, rules, and law, I can't respond to the allegations that you're saying, but I'd be happy to talk with you further privately to try and resolve any of those issues. So another area in which we tend to have problems is researching jurors on LinkedIn and Facebook. I mentioned previously that the whole idea of Facebook friends can be a problem, particularly with jurors and researching them. It is a problem. A lawyer cannot send a friend request to an actual or prospective juror, nor can we ask someone in our office to do it. We cannot have any communication with them, and we've interpreted Facebook friend requests as a type of communication. What you can do, at least according to the ABA, is look at information that's publicly out there for which you don't need a special request, even if the site is going to send a message that someone was checking out you and your profile. So LinkedIn sends those creepy messages sometime. There have been 5 people looking at your account. They include blah, 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 blah. That's okay, because me, as lawyer, I didn't initiate the contact. The site did it passively. But if I were to send a friend request or a request to connect on LinkedIn, that wouldn't be okay. Lawyers constantly get in trouble with this rule, mostly when they ask somebody else to do research on a juror for them. As lawyers, we're responsible for the people within our offices. So if we tell a paralegal or an investigator, I want you to dig up some dirt on a prospective juror, go see what's out there on their friend request. If I can't do it directly, neither can the person with whom I work. We're both constrained by the rules, and I'll be responsible for that person's conduct if either I told them to do it or I knew about it and ratified it. So the general rule, no ex parte communications with jurors or potential jurors in person or electronically when we have to proactively go out and communicate with them, initiate some type of communication. Now, we might be able to chat with others, witnesses, third parties, if we're honest about it. So let's say a former employee of an organization has some information. We're suing the organization. Former employee isn't represented. Completely okay as a lawyer to give them a call and say, hi, my name's Nicole Iannarone. I'm a lawyer. I represent your former employer, and I'm calling you to gain information about the substance of this lawsuit. I'm being truthful with them. I'm telling them what my interest is, that it might be adverse to their interest, so they can make an informed decision about whether to share information with me. We tend to get into more trouble, again, we aren't truthful about that information. If we just say, hey, do you know anything about this case, and don't express what our interest is in it and give them the opportunity to evaluate. Here's another one from Whisper. My secret. I just found out from my lawyer that I'm going to be at least $20,000 richer in about 30 days. It's been about a year now since I saw this story. Down in Florida, there was someone who, I don't know why all these cases arise in Florida, by the way. I open up with a leopard printed underwear. The settlement disclosure also arose in Florida. But in this scenario, a child of a client posts on Facebook, I'm going to Paris. Thanks, Dad's employer, for settling the lawsuit so that we're going to get to take a great post-graduation vacation. Problem: the settlement was confidential. The existence of the settlement was confidential. I raise this because we as lawyers need to talk to our clients about, if we're settling a case, what does it mean if you're starting to put these secrets out there, either by sharing them with your kids who might go and about them on Facebook, or by sharing them yourselves. In the Florida case, the defendants brought the Facebook post to the judge and said they violated the terms of the settlement agreement. They're done. The judge agreed. They lost all of the settlement funds. Bye-bye trip to Paris from one simple little post. I believe this is one you guys are all familiar with as well. The Panama Papers doesn't deal so much with social media, though I suppose it can if someone is able to get into your accounts through social media. I raise it because we as lawyers have a responsibility to ensure the safety of our clients' confidential information. Law firms are seen as soft targets for data theft. Several prominent law firms have been hacked. Foreign countries, hackers who are looking for state security secrets, which is a big one. I think it happened to one of the firms here in Atlanta. Another one that we hear quite a bit about is hackers who are looking for inside information upon which to trade so that they can make some money in advance of the market. The ethics rules don't give us a lot of guidance with regard to what we need to do. They say only we have to take reasonable efforts to protect the security of our clients' information. I don't know what that means. I think most lawyers don't know what it means, and it's where we need help from IT professionals to ensure that if we know, at least if we have a breach, we do something immediately to make folks aware of it. At least under the ethics rules, our obligation there would be to communicate with our client that a breach has occurred. There are state and federal laws that deal with data breaches that you have to address. But I think at this point, most legal ethics folks tend to agree that all law firms have to assume that they will be a target of a hacker if they haven't already been a target of a hacker and had some type of a data breach. This one I came up upon within the last week. This is a parody page, which is why it's called Todd Levitt 2.0. The real Todd Levitt apparently was an adjunct professor at a law school, and I haven't been able to locate his now deleted Twitter page. I'm sure somebody could help me find it. But apparently, according to an opinion, it said things along the lines of, again, adjunct professor, Jack Daniels is making an appearance in class tonight. Might have made references to, and I'm going to get the language a little bit wrong, Mama Marijuana on his own individual page. And it's something close to that. I don't want to be sued for libel and slander, so look up the opinion. But this is a parody page. Found out about it because he sued the individual who put this up and tried to retweet things that he said and make a new profile for him. The court ultimately said, look, you put this stuff out there. It is clear to everybody that this is a parody page. This guy keeps writing, this is not him, it's a parody account. You can find the real toddler at this other handle. But because he had created an internet presence where I think he called himself, excuse my language, the badass lawyer, it was all right for someone to begin to parody him. And this student recently won the defamation lawsuit and was allowed to keep the site up, much to the chagrin of the lawyer. I put this out there as a bit of a cautionary tale. Once you have information out related to your reputation, it's really hard to marshal it and get it back. And someone can make a parody pretty quickly, or retweet it, repost it, put it all over the place, and there's very little that you can do about it at that point in time. This guy had thought that his initial posts were helping him bring in clients. I think this type of a profile now associated with his name might make it a bit more difficult. He tried to show, I've lost clients as a result of the parody that's going on right now. So the hard part here is balancing as lawyers. We want to have information out there about ourselves, our practices, our wins, our clients, but at the same time, we've got restrictions and ethical rules. Most notably, confidentiality, because anything related to the representation, no matter what its source, is subject to confidentiality. We've got advertising rules, basic ones from whatever you say needs to be truthful and not misleading, to more technical, persnickety ones. Make sure your name and address listed on any advertisement you put out, at least in our jurisdiction. We have to worry about communicating with third parties and accidentally using something the wrong way or not giving the proper disclosure. And what I tell lawyers ultimately is, when it comes to technology, we can't be lawyer ostriches and put our heads in the sand. About what the technology does, how it's being used, and what do some of these phrases mean, particularly private pages. Are they actually private? In fact, I think I got this picture out of a Judge Posner decision, I think, where he's accusing someone of being a lawyer ostrich. A lawyer in South Carolina who was disciplined a couple of years ago, he said, you know, I put my hands up, I've been doing this too long. I don't like your court rule that says I have to have an email account to be practicing in front of this court. So he refused to get an email account for a while. They came down on him and said, okay, we're in the 21st century, you need to have email. Got an email account, and then he refused to check it. He also got sanctioned for doing that, and ultimately I think he lost his bar license because the court said, you have to use technology. So in the end, it's really a balance of doing the best you can for your clients, understanding technology is there and that you need to use it, while also not going too far in the other direction, making too much use of it in a way that's going to hurt your client. Early morning session, my caffeine has made me go a lot faster than I expected. And I'm certain that I have a lot, you guys may have some questions about this. So I'm happy to answer any questions that you have and also learn from you about anything that you've seen in lawyers, law students, and law professors using or misusing technology. What do y'all think?
Old friend. Active member of the Georgia Bar.
I've had judges endorse me, which really kind of freaks me out when I was in practice. So I don't show any of my endorsements. I don't want someone to assume that, oh, she's got a great relationship with this judge over here because he or she endorsed her for legal writing and research. It's a weird world. Anybody can press those buttons, and they don't have to have any knowledge about it.
Like I said, I have not approved that endorsement.
Yeah. The other thing. Even if it's technically we were in a jurisdiction that said it's not okay for you to go to LinkedIn if you know it's going to generate a statement to somebody else, why is it okay to do it privately if they can't figure it out? That's a little strange. There's always a maxim of law that I like to use when I can't find anything else, which is can't do indirectly what you can't do directly. So I'm not really sure why that's allowable, but some seem to think that it is. Back to the endorser as well. We're giving someone a recommendation for something. If we don't know what we're actually talking about, it can be a problem. And there is at least an academic argument about there for lawyers of if you lawyer recommend somebody else as a lawyer and they turn out to be terrible and you didn't do your homework and that individual you refer to them suffered a bad result, can you be sued for a negligent recommendation of somebody else? And I think you might be able to do that. Austin.
I have a question.
I think somewhere in the mix, I lost a slide that has a picture of an actual Groupon ad for, it is $375 to write an estate plan. So that raises all sorts of questions. I searched Groupon for law stuff. I'm in Georgia. I found this ad that was, I believe it was in Illinois. So if I don't live there, and he's giving me legal advice, is that guy engaged in the unlicensed practice of law? Depends on the different states' rules, but probably. Then there's the idea of client-attorney relationship. When does it start? A lot of the case law out there suggests that it's not up to us as lawyers when we think the relationship starts, but it's the actual belief of the client based on all the facts and the circumstances. So if, as Austin says, someone has put a blog post out there and starts answering specific questions about a legal issue, they might be getting a client. That's something that the ABA has cautioned against in one of its formal advisory opinions about ethics. You guys will probably think that some of they ask you to do is, look, if you're going to have the ability of a client to contact you and ask you a question directly from your website, a best practice is to put technology in effect so that they have to click through a disclaimer that says, you are not our client unless you are already our client, and anything you tell us might not be confidential. We're going to have to run a conflicts check. We might not keep it secret. And by the way, you're not going to be our client until we decide that you're going to be our client. Avo, LegalZoom, those types of sites allow lawyers to pop into a chat group and claim and answer questions. And a lot of the regulators have said, watch out if you're doing this. How much do you actually know about the individual when they post a question? Have you done a full analysis? Are you giving legal advice? First, you better make sure what you're saying is correct, which is a concern. But second, without having a full conversation with someone, can you even really give them full legal advice? And are you violating the UPL rules as well? I'm sorry, unlicensed practice of law rules.
What about an attorney operating behind a thin credits and legal advice? People have weird, crazy things they need to find out and someone chimes in, I'm an attorney in, I think, get an attorney, and then here's my opinion. That never, actual attorney is pretending to be an attorney, eventually comes back around to someone.
So here's my question. How anonymous is Reddit really? Bad advice, maybe. Fought cases in the past. I think you're able to do that in this internet world. Love it in terms of practice law without a license. Bad advice on one of those sites and you were a lawyer? Cocktail party and says, hey, I had this problem, what do you think? Sorry. I can't give you advice on that. If you want to talk about it, give me a call, come into the office, and we'll see if we can. I work at the reasonable rate. Happy to help you out then, unless I happen to absolutely know the problem and know the answer right then. And I guess that's also a disclaimer for this. We've been talking very high level, general principles about being competent, ensuring that you understand confidentiality, treating people fairly and truthfully when you're dealing with third parties, and ensuring that you don't give bad advice, right? Or do something that violates another law. There are specific, this isn't really legal advice for any one specific scenario. You have to look it up as you go through and understand what the rules are. And they change. Every few months, a new state puts out another opinion on social media, et cetera, and the practice of law. We lawyers can't keep up with how quickly it's all evolving. And so sometimes I sit on a board that issues those types of opinions. We look at the problem and say, you know, by the time we go through the formal process of researching this, writing an opinion, publishing it in a bar journal, soliciting comments, going through a second publication, and then asking the Supreme Court to approve it, the technology has changed. What's the point of doing that? A number of state bars have great resources in ethics hotlines, where you just call and say, what do I do in this scenario, semi-anonymously? Ask what they think about the problem. Yes, ma'am. Everything out there and they see nothing wrong. Privacy is at some point going to evolve. We might not be there yet, but just based on this generation, they have a different idea of it. Now, I have conversations with my students and say, all right, your employers, some of them, I don't think it's a good idea. Great idea to run web searches. To find something. Would you want them to see this? Want a client to see this? How does it impact the type of professional identity you have and the persona that you want to put across? Is a client going to hire you? I advise students on, I don't know Instagram, on Facebook, to go through and untag themselves in any photo that might be even remotely embarrassing, take yourself out of anything that has restrict your settings so that people can't tag you anymore unless they're friends, and if they're really good friends, ask them to untag you if you don't want to be in it. And stop. I personally don't friend my student. If a student sends me a friend request, I will not accept it on Facebook, and I wouldn't on Instagram either. I might on LinkedIn while they're a student. And I tell them, I don't want to do this because as a lawyer, I'm going to have to say to the bar, yes, I think this person is somebody who we can put a lot of trust in, who follows the law, who is responsible. And if I see something on one of these sites that indicates otherwise, I have to tell the bar about it. So be careful what you put out there. Be careful who you share information with.
Cases of extreme. Action happens in
Made all these promises about the information disappears. You put it out there, it's on for however many seconds, it's available, and then it's gone. They got sued for keeping the information cached somewhere. So it was available, and you don't know, even if someone promises private, it might not be.
students are getting
Screenshot? Yeah.
nothing is.
Well, I even think about, as I look at these monitors here, I'm pretty sure these are all smart TVs. Ethics alerts have actually gone out over smart TVs that have voice controls. I don't think these have voice controls, but I could be wrong about that. Because they tend to, I think they record all background conversations. So law firms have been advised, if you have a voice controllable smart TV, it is recording in the background all of the conversations that are happening, even when it's not trying to act on it. So someone could theoretically go into it and hear all of your private, confidential, attorney-client privileged communications. And that sort of raises a question of, now that we know that that's out there, have you waived the privilege by allowing yourself to be recorded and do that? I think certainly if you know about it and aren't taking any actions, you've got some competence issues maybe, and you might be violating confidentiality as well. Any additional thoughts as we wrap up?
On your computers, it might actually
What if somebody can get into?
be. The law school that I went to, social media in the law class.
When my class was teaching their research on business law, they made them read an article and write a reflection afterwards. And the article was about your estate and your digital identity. The procurer of all of those IDs. And oh my God, It's a great way of doing it.
Well, I wonder even, I don't know what's out there. I want you to go research everything. Show me what's out there.
That's true.
We do.
That's true.
That's the problem.
But then again, you know, it's something.
Absolutely, it's a great point.
Later on in the fall, because I am, one of the,